Morning. Yes, Mr. Sharma?
Lordship, item number 9,
Yes.
I think this has been wrongly listed.
Item number 9.
9. It's a bench 2 meter. It is shown as part hurt by slip.
I think there has been some mistake.
Yes.
There is another matter which was fixed. Probably that is also 7241. But what has been shown in the list is your matter,
Yes,
perhaps.
yes.
All right.
But I could not contact petitioner's counsel.
No problem, Mr. Sharma. File kuntu ahise, Rupak? Original to ahise. A to file to ahana? I'm told your file is not in the list,
Yes.
not in the court.
Yes.
So in that case, maybe no order is necessary.
Yes.
Are you appearing in the other one?
No.
We will check this, because if the file is not in the court,
Then the Lordship may not pass any order.
then I don't think any order is required. Most likely, this has come. What was supposed to come was 7241 of 2013. Are those lawyers here? Who's appearing in that case? Are they in court? No. All right. Anyway, we will see. Mr. Sharma, not to worry. Yes, please.
I may not be appearing in that group.
Lordship. Lordship, we give consent from the other side, which you mentioned, item number 3, Lordship.
Yes, what do you want?
Lordship, Mr. Deedas is leading the case, Lordship. He is not available today.
It is submitted at the bar that the leading counsel, Mr. Deedas, senior advocate, is not available today. Accordingly, accommodation is sought. List this matter after 2 weeks on a date to be fixed by the registry.
Lordship, 27, if...
Next.
High level.
Please, Lordship, I'd like to mention item number 7 here, Lordship. This is part of matter. Land Council, Mr. M.H. Laskar is under bereavement, your Lordship.
Is it?
Yes, your Lordship.
It is submitted that Mr. M.H. Laskar, learned counsel for the petitioner, is in bereavement, and accordingly accommodation is sought. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Much obliged.
Please, Lordship, I beg to mention item 10 on behalf of Senior Counsel I. Chaudhary. Lordship, due to some difficulty, he had to be out of station.
Mr. I. Borthakur, learned counsel for the petitioner, submits that Mr. I. Chaudhary, learned senior counsel leading the matter, is out of station, and accordingly accommodation is sought. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Problem.
Please, Your Lordship, we have filed a IA substitution for legal here of deceased petitioner.
You want it to be listed?
Yes, tomorrow.
Mentioned before the appropriate bench. Yes. Call the list, please.
Lordship, my senior Mr. H.K. Das is on legs in court 1. Kindly the matter may be passed over for the time being, Lordship.
It's come for the first time.
Yes, Lordship.
Then we'll call for the CD.
Lordship, scan copy of LCR, Lordship. Charge sheet and not.
It's a bail application.
Yes, Lordship. Earlier rejected by the Son.
So therefore, the scanned copy of LCR is required.
Yes, Lordship.
Scan copy may be called for. Lordship, any day before the vacation.
Call for scanned copy of the LCR from the court of so and so through the registry of this court. List on
25th, Lordship.
25 so and so. Yes, from the court of petitioner. You all don't open your files when you come to make a mention before the court. What kind of a practice you all have developed? Yes.
Session Judge Lakhimpur, Lordship.
Session Judge Lakhimpur.
May it please your Lordship, my senior is court number 26. Can we take this matter after some time? My senior is in court number 26.
No, in which matter are you submitting?
The management of Hindustan University.
I am giving the judgment there. You can sit and hear out the order. Today it is fixed giving orders.
May Lordship, please, I am on the VC, Your Lordship.
Yes, Mr. Das, arguments are over.
Yes.
Correct.
If any assisting is required,
I cannot hear you.
if any assistance is required, Your Lordship, then I.
Yes, of course. If any assistance is required, I shall ask you. You just be there. Thank you.
Yes.
This is for judgment. Huh? Heard Mr. B. Datta, learned senior advocate, assisted by Mr. J. Das, learned counsel for the petitioner. Stop. Also heard Mr.
KM Haloi.
For respondent, whose name?
KM Haloi.
KM Haloi, learned counsel for the respondent. Stop. By this petition under Article 226 of the Constitution of India, the petitioner is assailing the order dated 4/7/2017 whereby which page is the impugned order?
215, my lord.
Is assailing the order dated 4/7 so and so passed by the
Presiding officer, industrial tribunal.
passed by the presiding officer, industrial tribunal, Dibrugarh, comma, whereby the inquiry held by the management has been held to be not valid. Stop. The facts of the petitioner's case is as follows. Four workmen of the petitioner's company were dismissed by the management after issuing necessary notices and holding inquiry. Stop. Pursuant to the inquiry held, the management issued dismissal orders to the concerned workmen. Stop. Thereafter, conciliation proceedings were held and matter was referred to the Industrial Tribunal Dibrugarh for adjudicating the reference as regards
Page 4 of the writ petition. Page 4, para 2.
Page 4.
Yes, Lordship. Page 4, para 2.
Number 1, whether the management of Hindustan Unilever Limited are justified in dismissing the services of Nirendra Burman, Shri Nobo Gogoi, Shri Sanjeev Moran and Shri Jintu Tamuli, i.e. the respondent number 427 from the company with effect from 6/9/2010. Number 2, if not, whether the 4 workmen are entitled to reinstatement with full back wages. Number 3, if not, what other relief the workmen are entitled to. Stop. Thereafter, both the management and the workmen side submitted their pleadings before the industrial tribunal. Stop. The industrial tribunal framed the preliminary issue as regards the validity of the inquiry held by the management as stop. Accordingly, the preliminary issue was taken up for hearing, whereafter the learned tribunal, after hearing the parties, hold that the inquiry held by the management is not proper, and accordingly allowed both the parties to adduce further evidence if they desire in order to decide the reference on merit. Stop. The said order of the learned tribunal is under challenge before this court. Stop. Mr. B. Datta, learned senior counsel, submits that the order of the tribunal is absolutely erroneous inasmuch as despite the erroneous full stop, he further submits that the inquiry was held properly after giving due opportunity to the workmen. Stop. He further submits that the order of the tribunal holding the inquiry to be improper is absolutely without application of mind and perverse. Stop. In support of his submissions, he relies on the decision of the apex court in the case of number 1, Shri Enamal and Stamping Works Limited versus their workmen, AIR 1963, Supreme Court 1914. Number 2, State of UP versus Horendra Arora, 2001, 6 SSC 392. Number 3, Union of India versus Alok Kumar, 2010, Volume 5 SSC 349. Number 4, Crescent Dyes and Chemicals Limited versus Ram Naresh Tripathi, 1993, 2 SSC 115. Number 5, Bharat Petroleum Corporation Limited versus Maharashtra General Kamgar Union, 1999, Volume 1, SSC 626. Number 6, DG Railway Protection Force and others versus K. Raghuram Babu, 2008, Volume 4, SSC 406. Number 7, Cholan Roadways Limited versus G. Thirugana Sambandam. I'll give you the list. 2005, 3 SSC 241. Number 8, State Bank of India versus Vidyut Kumar Mitra, 2011, 2 SSC 316. Number 9, Sanjay Kumar Singh versus Union of India, 2011, 14 SSC 692. 2018, next case, ML Singhal versus Punjab National Bank, 2018, volume 18 SSC, page 21. This is 2-1 or 4-1, Mr. Datta?
2-1.
2-1. And 11, State Standard Chartered Bank versus RC Srivastava, 2021, volume 19 SSC 281. Okay. Mr. So-and-so, learned counsel for the respondent, on the other hand, submits that the writ petition is not maintainable as the petitioner has challenged the validity of the domestic inquiry, which can be assailed by the petitioner company, if ultimately the award is passed in favor of the union. Stop. In support of the aforesaid submission, he relies upon the decision of the Supreme Court in the case of Cooper Engineering Limited versus Sri P.P. Mundhe, reported in 1975, Volume 2, SSC 661, and the judgment and the decision of this court in the case of Pratapgarh Tea Estate versus Hiran Bhumis, reported in 2015, SSC Online, Guwahati 349. Stop. I have heard the submissions made at the bar and have perused the materials available on record and have also considered the decisions cited at the bar. Stop. In Delhi Cloth and General Mills Co. versus Ludbud Singh, reported in 1972, Volume 1, SSC 595, the Apex Court has held that where no inquiry was conducted by an employer or the inquiry itself was found to be defective, the employer shall have to be given a chance to adduce evidence before the tribunal for justifying his action, provided the employer asks for the permission of the tribunal to adduce fresh evidence to justify its action. Such request has to be made within quotes while the proceedings are pending and not after the proceedings had come to an end. The following propositions were laid down. Number 1, 2, 3, 4, 5, 6, 7. This I will give you. It is at page 525. I have put a pink flag. Okay. Stop. Next paragraph. These principles were adopted in Workman versus Firestone, Tire and Rubber Company of India Limited, reported in 1973, Volume 1, SSC 813, which was decided after the introduction of Section 11 capital A in the Act. Stop. Then you say in Nita Kaplish versus Presiding Officer, Labour Court and another, reported in 1999, Volume 1, SSC at page 517, the Apex Court has held that in all cases where inquiry has not been held or inquiry has been found to be defective, Labour Court / Tribunal can call upon the management or the employer to justify action taken against the workman and to show by fresh evidence that the termination or dismissal order was proper. Stop. If management does not lead any evidence by availing of this opportunity, it cannot raise any grouse at any subsequent stage that it should have been given the opportunity, as the tribunal in those circumstances would be justified in passing an award in favor of the workman. If, however, opportunity is availed of and evidence is adduced by the management, validity of action taken by it has to be scrutinized and adjudicated on the basis of such fresh evidence. Stop. Paragraph 24 and 27 of the said decision is reproduced hereunder for ready reference. Stop. Next. Next paragraph. What follows from the aforesaid decision is that in such cases where the dismissal of a workman is under reference before the industrial court, the management has a right to either rely upon the inquiry which it has held or to lead evidence before the industrial tribunal afresh. Stop. If the management chooses to rely upon the inquiry so held, the tribunal shall try the validity of the inquiry as a preliminary issue. Stop. If the findings of such adjudication is in favor of the management, the matter comes to a rest there itself. Stop. However, if the finding of the tribunal is that the inquiry so held is not proper, the management in that case, if asked, shall get the opportunity to lead evidence afresh. Stop. Next para. In the case in hand, it appears that the validity of the domestic inquiry was adjudicated as a preliminary issue, and upon adjudication, the tribunal has come to the finding that the inquiry held by the management is not properly held and as such has vitiated the proceeding of the domestic inquiry. Stop. Accordingly, the presiding officer, Industrial Tribunal Dibrugarh, decided the preliminary issue against the management. Stop. It appears that after adjudicating the said issue against the management, the Industrial Tribunal, the presiding officer, Industrial Tribunal Dibrugarh, was pleased to give chance to both the parties to adduce fresh evidence if they desire in order to decide the reference on merit. Stop. Accordingly, the matter was fixed on 27/2017 for submissions on affidavits in lieu of examination in chief by the workmen, if any, as further evidence. Stop. However, since the said order of the Industrial Tribunal was put to challenge in this writ petition. You had obtained stay, Mr. Datta?
Yes, Lordship. Yes.
And stay orders have been obtained from this court. The reference, further proceedings of the reference were kept in abeyance till date. Stop. Though arguments have been placed before this court by the learned senior counsel appearing on behalf of the petitioner that in a given case where there is an error of law, comma, the award of the industrial tribunal deciding the preliminary issue can be challenged under Article 226 Constitution of India before the final award is passed, comma, this court is not inclined to accept the aforesaid submission. Stop. The issue as regards challenging the order of the industrial tribunal deciding the preliminary issue before the final award is passed has already been settled by the Apex Court in the case of the Cooper Engineering Limited versus Sri P.P. Munde, reported in 1975 to SSC 661. Para 22 of the aforesaid judgment is reproduced hereunder for ready reference. Pertinent to also refer to the decision of this court in Pratapgarh Tea Estate versus Hiren Bhumis, reported in 2016, 1 GLR 312, wherein this court, by relying on the decision of the Apex Court in Cooper Engineering Supra, declined to interfere with the decision of the Labour Court on the preliminary issue of validity of the domestic inquiry pending decision on the final pending adjudication of the reference. Stop. Paragraph 26 and 27 of the aforesaid decision is reproduced hereunder for ready reference. Stop. The grounds urged by the learned senior counsel to contend before this court that the order of the industrial tribunal is erroneous is not gone into at this stage. Stop. However worthy the aforesaid grounds may be, comma, the same can be taken at the time of challenging the final award if necessary. Stop. Accordingly, the writ petition stands rejected. Dismissed, no cost. Sorry, Mr. Atta.
No, not a problem. Grateful, Lordship.
This is the list, and this is the pink flag. You get it. Ekuni bosto yate thoi dibo ha. Mai ebar correction moment lagibo pare.
Grateful, Lordship. Yeah.
Yes.
No.
Item number 2.
Change her. Yes. Mr. Talukdar.
I have received some instructions.
Yes.
Now they have started the exercise. The hearing has been fixed. notices are issued to the parties.
No, but I think specific instructions was whether the case of the petitioner has been disposed of.
No.
No.
Now the hearing has been.
Hearing has started. Have you shared the information with the other side?
I'll give the copy.
Yes, what is to be done?
No, Lordship, if the hearing is there, and Lordship, date may be fixed within that date, we can complete the exercise.
You mean I can dispose of?
Date of hearing is July, my 20th.
Can this petition be disposed of? Mr. Talukdar? Since
hearing has taken place.
Correct.
They will do the exercise and pass orders.
In accordance with law. I can. The only thing is, it's not correct all the time to give them a time frame.
Because this exercise has been done from last 12 years, Lordship.
All right, 3 months. I'll give your name, Mr. Deka. Heard Mr. P. Deka, Learned Counsel for the petitioner. Stop. Also heard Mr. B.J. Talukdar, Learned Additional Senior Government Advocate for the state respondent. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is seeking direction to the respondent authorities to explain the delay caused in giving effect to the order dated 7/3/2013 passed in WPC number 4995 2005 and subsequent in WPC number 4958 of 2018. Stop. And or direction to the respondent authorities to take in terms of the decision of this court passed earlier on 7/3/2013. Stop. Quite a long synopsis. The facts of the case of the petitioner are as follows. The petitioner company in the year 1959 purchased three grants with an area of 810.31 acres. No, three grants, with three grants belonging to one Sri Radhikananda Chaudhary, Vide Chandrapur Satpukhuri grant with an area of 810.31 acres, Chandrapur Tantimara grant with an area of 181.331 acres and Ahirgaon with an area of 258.30 acres by a registered sale deed for valuable consideration executed on 21/11/1959 and which was duly mutated on 6/10/1961 for purpose of setting up its factory. Stop. A land selling case being number 205 of 63 was started against the previous owner of the petitioner company, and the petitioner company was allowed to retain only an area of 586 bigha plus 150 bigha on retainable limits by the SDO. Stop. Mr. Deka, please take your seat. Next part. Being aggrieved, the petitioner company preferred a writ petition being civil rule number 309 of 68. Stop. Wherein Stop. Wherein this Honorable Court, vide order dated 16/6/71, allowed the writ petition and set aside the impugned orders of the SDO, Guwahati Sadar, and also the appellate order dated 22/7/1968. Stop. Next para. In the meantime, the said petitioner company was nationalized under the provisions of Sikh Textile Undertakings within bracket Nationalization Act 1974 with effect from 1/4/1974. And since that day, the provisions of the Sealing Act became inapplicable to the lands of the petitioner company. Stop. Another land sealing case being LC case number 364/76 was initiated against the petitioner company, although under the provisions of the Nationalization Act, no such proceeding is permissible. Stop. The petitioner company was found to be in possession of 200 bighas of land, but the petitioner did not accept the same. Stop. After various litigations regarding the land selling case, the collector Kamrup within bracket Metro disposed of the land selling case number 364/76, vide the order dated 16/7/2004, directing the concerned staff to prepare the final statement retaining 212 bighas, 03 kathas and 8 lechar of land in the name of the National Textile Corporation, and also ordered the circle officer Chandrapur Revenue Circle to correct the land records as per the final statement in the name of the National Textiles Corporation. Stop. Pertinent that the spot verification and the reports of the circle officer suffers from lacuna and infirmity, and as such being aggrieved, the petitioner company preferred a writ petition being WPC 4995 of 2005. Stop. This Honorable Court in WPC, in the aforesaid writ petition, with its judgment and order dated 7/3/2013, was pleased to set aside the order dated 16/7/2004 passed in RLC case number 364/76, and the matter was remanded back to the Collector and Deputy Commissioner Kamrup Metro for a fresh decision upon hearing all the parties. Stop. Thereafter, the concerned unit in charge of National Textile Corporation Limited, Chandrapur, has been time to time pursuing the matter with the Deputy Commissioner at Metro Office in the Revenue Branch, but no any action from the said office concerned has been taken in spite of receipt of the said judgment and order dated 7/3/13 since the year 2013. Stop. Next paragraph. As such, the petitioner company in the year 2018 filed a writ petition being WPC 4958 of 2018, praying therein for issuance of writ in the nature of mandamus, directing the respondent authorities to take steps for fresh decision within a time-bound period on the land sealing matter, being LC number 364/1976. After hearing the parties, as per the direction of this Honorable Court, vide judgment and order dated 7/3/2013, passed in WPC number 4995 of 2005. Stop. In the aforesaid writ proceedings, this court directed this court on 27/7/2018 was pleased to direct the Deputy Commissioner Kamrup Metro to take note of the order dated 7/3/2013 and dispose the matter representation afresh as contained in the order dated 7/3/2013 within a period of 3 months from receipt of the certified copy of the order. Stop. Next paragraph. Accordingly, the petitioner company preferred a representation to the Deputy Commissioner Metro Vide memo number on 10/8/2018 with a prayer to dispose of the land ceiling matter being LC case number 36476 in terms of the order passed by this court on 7/3/2013 and 27/7/2018. Stop. Since the aforesaid representations were still pending, the present writ petition was necessitated to be filed. Correct? Stop. Heard the parties at length and perused the materials available on record. Stop. Today, during the course of the hearing, Mr. B.J. Talukdar, learned additional senior government advocate, places a communication dated 15/6/2024 issued from the office of the Additional District Commissioner, Kamrup Metro District, whereby it is informed that the order dated 27/7/2018 passed by the Honorable Guwahati High Court in WPC number 4958/2018 is being actively pursued at their end. Stop. It is further informed that a notice for hearing Vide number KRL-17/2018/57 is also issued to the concerned persons for disposal of the aforesaid case, and the date of hearing has been fixed on 15/7/2024. Stop. A copy of the aforesaid instruction is also furnished to the other side, and the same furnished to the other side. Stop. A copy of the said instruction is placed on record and marked as X. Stop. It is unfortunate that despite the petitioner has obtained 2 orders from this court whereby the representations of the petitioners was directed to be considered by the respondent authorities, despite lapse of several years, the said representations of the petitioner has not been disposed of. Stop. Writ remedies are not for executing orders passed by this court under Article 226 of the Constitution of India. Stop. However, because of such non-action of the state respondents, such petitions for executing the orders passed by this court has to be filed. This court depreciates such practice, such non-action of the state respondents. Stop. Be that as it may, since the state respondents have communicated, have fixed a date for hearing to in terms of the order passed earlier by this court on 27/7/2018 in WPC 4958 of 2018, this court is not going further in the said matter. Stop. However, in view of the aforesaid endorsement made by the learned additional senior counsel, senior advocate, state respondent, this court deems appropriate for the ends of justice to dispose of this petition with a direction to the respondent authorities to complete the exercise in terms of the orders passed earlier by this court on 7/3/2013 in WPC 4995 of 2005 and 27/7/2018 in WPC number 4958 of 2018 within a period of 3 months from the date of receipt of certified copy of the order. Stop. Needless to clarify that non-compliance of the aforesaid orders would invite adverse consequences. Stop. Disposed of. Writ petition success, disposed of.
Lordship, within 3 months from 15/7.
Sorry?
3 months from 15/7, Lordship. The date,
I'm sorry?
3 months from 15/7, Lordship.
3 months from?
15/7,
Date of hearing.
date of hearing.
Next date of hearing. And Lordship, they will have to cooperate.
We will always cooperate.
Mr. Talukdar, the less that you say is better for you today.
Because there are so many other parties also.
You want 3 months from 15/7? Oh, that is the date for hearing. All right. 3 months from the scheduled date fixed for hearing. Okay? So that is even if something on 15/7, if the hearing doesn't play, whenever the hearing takes. I'll edit that part. And on top you say GN Sahewala, learned senior counsel, assisted by Mr. Deka. Anything more?
No, madam. Highlight.
It X koi le loga.
Item number 4.
Etu kiman asile? Disposed of.
Maybe.
This is item number? Yes?
Yes, on the last occasion.
Contractual.
Yes.
Yes.
On the last occasion.
Lordship, we have intimated the PWD department about this.
Intimation is no good, ma'am.
Lordship, we are still awaiting the instructions.
No. Otherwise, everything is done. Lordship can dispose it of with direction to pay within 2 months.
You are for PWD?
Yes, Your Lordship.
Which document shows that this is admitted?
Yes, there are many documents. Page 33, page 36.
Page 33.
33 is the utilization certificate.
Yes, you had shown me, I think, on the last.
Yes. Page 36 is the demand proposal.
And page
36
is the
demand proposal.
This is by them.
Yes.
All right, I'm disposing it off.
Yes.
You make the payments within 3 months.
Lordship.
Item number 3, huh? 4. Heard Mr. B.P. Bora, learned counsel for the petitioner. Stop. Also heard MS.
A. Borthakur.
A. Borthakur.
For P. Nayak. For respondent number 1.
For respondent number
1, 3, 4 and 5. Your
3,
Lordship.
4 and 5. And?
R.M. Barwa for Mr. H.L.A. for respondent 2, Your Lordship.
And MS?
R.M. Barwa.
R.M. Barwa for respondent number? 2. The case of the petitioner is that despite of order passed by this court on 15/7/2009 in WPC 2791/2009 directing the respondent authorities to pay the contractual bill amount to the petitioner in terms of the decision in Tamsher Ali and others versus State of Assam and others reported in 2008-4 GLT 1, the same is not done till date. Stop. Correct?
Yes.
So you had already got one order.
Yes, page 25.
Page?
25.
Stop, huh? Then you write. Mr. B.P. Bora, learned counsel for the petitioner, submits that despite of the utilization certificate issued by the executive engineer PWRD Dibrugarh to the effect that rupees 11.61634 lakhs has been sanctioned in favor of the petitioner, correct?
Yes.
Comma, and the demand proposal issued by the Chief Engineer Roads PWRD Assam Chanmari, wide letter dated 2/2/2022 for releasing the amount of rupees 11.61634 lakhs in favor of the petitioner for the work done, comma, the same has not been done till date. Stop. MS. So and so learned counsel for the respondent submits that submits that she has received no instructions to object to the prayer of the petitioner. Stop. Correct? It appears that the petitioner had earlier approached this court by way of WPC 851 of 2021, wherein this court...
2791.
Sorry?
2791/2009.
Not the one at 37?
No, that I just annexed some similar orders.
Which one is yours?
Page 25. It starts from 22.
All right. By way of another ki likhila Bhargav? WPC 2791 of 2009. 2009, wherein this court directed the was pleased to dispose of the said writ petition in terms of the decision of this court in Tamsher Ali and others within bracket Supra. Stop. Relevant portion of the aforesaid order is reproduced hereunder for ready reference. It is admitted at the bar. Correct Sinata Maridisu, page 25 of Asa till page 26. It appears that despite the petitioner has obtained positive orders for release of the admitted contractual payments due to the petitioner, the same has not been done, for which the instant petition had to be initiated in the year 2023. Stop. It is absolutely unacceptable that because of non-action of the respondents, because of non-compliance of the respondents in non-compliance of respondents, petitions have to be filed before this court for executing the orders passed by this court. Stop. It appears that the dues of the petitioner has already been admitted by the executive engineer and the chief engineer roads PWRD, Assam, Chanmari. Stop. In view of the aforesaid admission, this court is of the considered view that this writ petition can be disposed of in terms of the decision of Tamsher Ali, Supra. Stop. I think that is enough.
Yes.
Isn't it?
Yes.
Anything more?
No, Lordship. In my case, verification has already been done.
Correct. Verification is done, it appears.
Yes.
So, in terms of Tamsher Ali, or I'll direct to release?
Direction to pay, because verification is
Tamsher Ali to move for area. Then you say, in view of the aforesaid admission of the respondents, this court is of the considered view that this writ petition can be disposed of with a direction to the respondent authorities to release the admitted contractual bill amount to the petitioner in accordance with law within a period of 3 months from the date of receipt of the certified copy of the order. Stop. Disposed of. All right?
Deeply obliged.
For here is item number 5 and 6.
This is that brick claim.
Brick claim method, that imposition of royalty method.
What is that?
This is the written argument as your lordship has sought after.
All right, then I'll post it on another date. Let me have a look at it.
Yes.
One more thing, Malad, if you also recollect, the other day, Council for the Revenue Department has made an argument that they have
made a law under Article 162. But
Mr. Saikia, let me have a look at this. You can, or you have. I think I had asked you also to submit something. Did you prepare anything?
I became handicapped because of that. The argument was made that an order has been issued by the government of Assam under Article 162. But I did not find in the their affidavit, nor there is any statement to that effect. So order be placed in the record so that matter can be.
Have you given a copy of the written argument?
No.
I'll
provide.
Share.
Yes.
Have a look at the arguments. If they are still making that argument on the written argument submitted, then on the next date we can direct that. Right? You have a look at it. Otherwise, this court shall not go into that.
Therefore.
So you have a look at it and you give your reply
That
written argument.
day the hearing had to be deferred because of that argument.
Understood. Now they have submitted something. So let us have a look at it. A written argument has been submitted on behalf of respondent number 7. Stop. Let a copy be furnished to the petitioner. List this matter again for further hearing on. Did yeah?
Item number 8.
You have a look at it.
Yes.
My Lord, in this case, my Lord, as promised, my written argument is ready, so I'm handing it over. In fact, my Lord, I'm down with viral fever, body ache, headache, fever and everything since last 2 days.
Mr. Tiwari, same thing this side also. I had a tooth extraction because of which I'm having a lot of difficulty in speaking.
So, my Lord, since our side is complete, I argued also
have you received a copy?
No. I will hand over the copy.
Mr. P.K. Tiwari, Learned Senior Counsel, submits a copy of written arguments on behalf of the petitioner. Stop. A copy of the said argument is also furnished to the other side. List this matter again on the date video.
And my Lord, if
for further hearing.
to give written argument?
No. On that day, if required, I shall give a written argument.
Because, my Lord, in that case,
Mr. Rajgupta, if you give it, it would be better because on that day I can dispose it in the court.
All right.
Because, my Lord,
then I will give it.
If some point is required to be clarified from his written argument.
In the meantime, respondents may exchange their written arguments in advance.
I have already given him. So
Respondent?
Yes.
Take rest.
All right.
Got it.
25th July.
Very well.
You please give your argument before that.
Yes.
You can give it to my court master and a copy to them.
Applied.
That would facilitate this court to dispose it of early.
Yes.
Lordship, the petitioner's land was acquired by the SP Kashar way back in 1972, and checkpost was established in 1973. And since then, he has been submitting representation for compensation of the land, and same has not been settled till now.
You have not got compensation?
Not yet, Your Lordship.
72 your land was taken?
Yes.
And checkpost was?
Yes.
This was taken by?
By SP Kachar for establishing a
Yes, Ms. Barman.
It's file seen by Mr. H. Sharma, my lord. Just give me some time. I am reading the affidavit, my lord. Give me some time.
That cannot be, Ms. Barman. Yes, Mr. Nath.
We have already filed additional.
Can that be done?
Affidavit is filed, my lord.
Otherwise, who was taking care of this matter? He should have been here. Isn't it, Mr. Nath? This matter has been fixed for hearing. Anyway, Ms. Barman, if you want time, this court will give you.
No, I'm just going to read this affidavit, my lord. Give me 5 minutes. No, I signed that I have this.
My written argument is ready along with some Supreme Court observations in this matter.
That is all right. Are you carrying that Kolkata Municipal Corporation matter case recently disposed by Supreme Court? Mr. Nath, you're aware of that?
I am not.
Ms. Barman, you do one thing, get hold of that. Because there is a very recent judgment of the Apex Court, Kolkata Municipal Corporation, wherein few parameters have been given. the rights which are said to be, even if they are not fundamental rights, they've been held to be fundamental rights in such cases. So have a look at it.
Yes.
You can, because you see, admittedly compensation has not been given and his land has been utilized.
Yes.
So how to go further? That would be an issue, right? So have a look at it. It's a serious matter otherwise. We'll post it on, yes?
Tuesday, Thursday.
List for further hearing on Tuesday. Date to date. You, do you want to give your written arguments?
Yes, Your Lordship.
You exchange it with Ms. Borman. Have a look.
My lord. Copy that it is on side.
Yes. ये मैटर को नहीं जाएंगे Tuesday. Mr. Nath, you are appearing in this matter?
Lordship, I am appearing for respondent number 5, 6 and 7. On last occasion, Lordship has directed the APGCL and the Karbi Anglong Autonomous Council to take an instruction. Basically, the Karbi Anglong Authority, they have to say, how
instruction on the last occasion we were.
You are still waiting?
Yes,
how much more time?
Lordship, she will stand kindly be granted.
Ms. Borman?
Immediately after
the opening.
But you please have the positive instructions because these are matters of 2015.
I have a small prayer, Lordship.
Yes,
Admittedly, land has been utilized and compensation has not been paid. It is the revenue authority to decide. Therefore, Lordship can dispose of in the next date with the observation that petitioner will submit application, fresh application.
Even in this matter, you have a look at that Kolkata Municipal Corporation.
I'll check up. Look, here, I'll check up. Otherwise, these are annual patta land, and in fact, the communication of the authority in 2006, APGCL has sought for government land for the Hyrel project. They have given us one line is written there that if anybody is affected, then we have to pay the compensation to the affected person. Here, what I find, a joint inspection report was there. Report suggests that 94 bigha land has been affected. 94 bighas of land. There are some affected persons. Some of them are petitioners. Some of them are not petitioners. But since the lands are annual patta land, if at all they are affected, they will get compensation for zirat, not for the land acquisition compensation. That ultimately the pattas were issued in the year.
So the instruction would be required.
Has to be
Once the instructions come, then you can decide on the further course of action, isn't it?
Yes.
So you have it. MSR wrong. MS? S-Chemprad. Learned Counsel for KAC assures that the instructions sought for by this court earlier shall be positively placed before this court within a period of 3 weeks from today. Stop. List after 3 weeks. List this matter on such and such date. Needless to clarify that if the instructions sought for is not placed before this court on the next date of listing, this writ petition will be disposed of in accordance with law on the next date. An endeavour shall be made to dispose of the writ petition on the next date.
May I please?
There was some change of counsel.
Yes, Lordship.
Are you the new counsel?
No, I am for the petition, Lordship. Respondent number 3 and 4, Parvez Sweden.
Who are the new counsels? Have they appeared? S.K. Ghosh.
Name has been reflected, Lordship.
They are not there.
None there, Lordship.
It appears that though the name of the new engaged counsel for the respondent numbers 3 and 4 have been reflected in the cause list, none represents the said respondents when the matter is called. Stop. Next week, Mr. So-and-so, learned counsel for the petitioner, is present.
D. Kalita.
D. Kalita. List this matter next week. On next week. If on the next week they are not there, we will proceed.
On 27th, Lordship.
20.
Comply.
Needless to clarify that on the next date of listing, if the said respondents are not represented, this court are not represented, there will be no embargo for this court to go ahead with the hearing of the matter.
Comply.